And I don't have any way to download it.
Mr. Seda.
The court is a trier of fact. You're going to be able to determine whether something that has come in, if you choose to, is hearsay, whether it's admissible, whether it's relevant, whether it's impeachment. You're in a position that if it all comes in, but you reserve the right, or all parties reserve the right to object, we can deal with it. This is not a jury. We don't have to worry about the jury hearing something that it will no longer consider. All we're doing now, with all due respect, and I understand there's a process, the state doesn't want something to be heard.
I object to that.
They've repeatedly attempted to stop questioning. Your Honor can hear it all and then decide what is and is not relevant or admissible. We don't have to go through every single one of these. The only time we have to go through this is if it is in fact a communication, and it's a privileged communication, and an argument has to be made at that point as to whether or not it should be elicited or it is subject to being stated in open court. Otherwise, all of this could come to the court, and the court can then decide how it wants to treat it. That's
all right. I appreciate that, Mr. Seda. I think it's certainly accurate that we could have an approach where if it's a close toss-up on an evidentiary question, we can have it all come in and sort it out later on the record. I don't think we've quite reached the point where I need to do that. I think we still have time to get into these, and it'd be my preference to keep the record as clean as possible and without questionable evidentiary issues. But we may get to that point. So the question from Ms. Merchant was to approach the witness and with an object to see if that would refresh his recollection to the last question asked.
Yes. Now, I'm sorry, the state scrolled through it, so not right there again. No, I mean like it was on the screen. Now I can't find it. So I'm going to move on to the next question that I actually can find, and then I'll find that and come back to it. I sent you a statement and said, upon information and belief, Willis and Wade met while both were serving as a magistrate judge and began a romantic relationship at that time, and you corrected me and saying, no, it was in municipal court. Is that correct?
I think that's pretty accurate.
And is that based on your personal knowledge?
But what question, was it municipal court or when they first met, or?
My question was, is this accurate? Upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. And you wrote, no, that it was municipal court.
Okay.
So I answer.
Bradley, just a second. Mr. Chopra has risen.
All right. Your Honor, I do have one purpose here, and that purpose has now been met. Any information that Mr. Bradley may possess would in fact have come from his representation of Mr. Wade. This falls within the purview of his divorce proceedings, which, as we testified earlier, commenced in December of 2018. There's no pierce or shield associated with it, and so we would say that under Rule 1.6 we should not be compelled to give any further information.
Okay, and as we discussed about before the break, Mr. Chopra, if I ruled earlier this morning that this witness is going to be directed to respond to any question to the extent it falls outside of attorney-client privilege and only attorney-client privilege, meaning 1.6 is not going to bar his testimony in this case. What would be your response then?
Then Mr. Bradley would have to consistently assess on his own, unless I'm jumping up and objecting for him, whether or not this came within his knowledge based on his representation. Now, I can say based on the phrasing of the question from Ms. Merchant, it would in fact come within information obtained from his partner, client at the time associated with the activity in question.
All right, Mr. Evans, same issue?
I just want to reiterate that it's a compound question anyways, that so it needs to be separated out, but it's still based, we just renew the objection that it's still based on gossip, either gossip or privileged communication. He doesn't ever cite the source of where any of this information is coming from, so I just wanted to make that objection.
Okay.
Judge, as far as privilege, any privilege objection, it's been waived, particularly for this issue because Mr. Wade
You did testify on this subject.
testified on this subject.
Well, he didn't testify as a communication with his attorney about any subject. He testified factually about what trips he took and events that occurred. He didn't testify, to my recollection, about any communication with his attorney.
But he testified about the subject matter of the question that was just asked, which was when apparently they first met.
Furthermore, Judge, my client wasn't privy to that testimony. We have been under subpoena and therefore under the rules, so we do not know what was or was not
Sure.
testified to. Everything he says would be a violation of that privilege unless we know specifically what all has been waived.
Sure, unless I make a finding that there was an express waiver on behalf of the client.
Yes.
Per question.
Okay.
And,
Sure, got it.
So
All
for
right.
this question particularly, Judge, we would ask that you find that there has been a waiver of the attorney-client privilege because Mr. Wade testified to something directly different than what this witness, we believe, has knowledge of.
Ms. Cross?
Yeah, so Mr. Wade testified as to when they met. That is not the entire substance of the text message that Ms.
And began a romantic relationship.
Yes. He did not testify that they
Okay.
were serving as magistrate judges when they began a romantic relationship.
All
He
right.
testified differently.
Okay, Ms. Merchant, I think you're going to need to establish whether this witness ever gained that knowledge independently or during the course of a attorney-client relationship.
Did you have any, thinking back to the source of your knowledge, and let me just, before I do that, let me remind you of what is covered by attorney-client privilege. It's communications that relate to matters in which legal advice is sought, and communications that have been maintained in confidence, and no exceptions to the privilege. So it's communications that are in furtherance of legal advice. Your knowledge that their affair began, that their romantic relationship, began while they were both serving as municipal court judges. Is that from your personal information, your personal knowledge, or is that from?
I'm going to overrule that objection, Mr. Chopra. He can answer that question.
State that question again.
Your knowledge,
Is any knowledge, if any,
knowledge, of Nathan Wade and Fani Willis's relationship, romantic relationship beginning while they were both serving as judges, is any knowledge that you have from your own personal knowledge or something that was told to you in furtherance of legal advice?
I have no personal knowledge of when it actually happened. I was not there. I do not have any personal knowledge, so
Okay.
I would choose not to answer that question under 1.6.
Mr. Bradley, we made a distinction earlier
Yes, sir.
that it's a bit narrower than that.
Okay.
1.6 is
I have no personal knowledge, Judge. I apologize.
Okay.
If you were,
That's not a problem. The issue is attorney-client privilege, and so whether what you learned, if anything, was during communications with a client.
It was.
Okay, Ms. Merchant.
and was it that any knowledge that you had as to the truth of that statement, was it told to you in furtherance of legal advice?
I'm going to object to it if that statement is true.
That's how I am.
And the witness has already testified he has no personal knowledge about that. So whether he represented at one point it was true or not true, he has no personal knowledge about that, so could not testify.
Prior inconsistent statement, Judge. Do it all the time. That is what the state
It's
does
not a
regularly.
statement.
They bring in, if it's a prior inconsistent statement of another witness, Judge. Mr. Wade
Which
testified.
other witness?
I'm
Okay.
sorry.
Okay, Mr. Wade testified.
That their relationship did not start.
But you can't impeach him with a prior inconsistent statement that's privileged. And so we haven't gotten over the privilege hurdle.
The
You said-
privilege hurdle we've gotten over with fraud on this instance.
Well, that's the first time you use that word. So if you want to make the argument of why that applies, you can do that now.
Yes, Judge, the crime fraud exception, it applies because of the crime fraud exception.
Which crime and or fraud was committed here?
So there's a couple different things, and I want to just address them both because he's raised 1.6 and also raised attorney-client privilege. For the crime fraud exception says the privilege doesn't apply if it's if the existence of it, essentially if he has to keep something secret to allow a fraud upon the court to continue. So we've got that. We've also got
No, it has to. The legal communications have to have done in furtherance of a crime or fraud. How has that been established? And what crime or fraud are we talking about?
We're talking about perjury, lying to the court.
In the affidavit filed last month.
Yes.
And so what have you done to link the communications that he made maybe, I don't know, years ago to the affidavit filed last month?
The communications he made years ago, it's proof of the affidavit being incorrect, being false. He's given a prior inconsistent statement.
But the legal communication has to be in furtherance of a crime or fraud.
Right. Right, but he also can't protect. So, and I think it's more under.
But if he had no idea, an affidavit wasn't even going to need to be filed until a month ago.
Right.
And these communications and everything happened well before that. How is anything that they communicated in furtherance of that affidavit that they didn't even know would have to be filed one day?
It's been waived. That part's been waived because he filed the affidavit. So you can't file something that's false and then your lawyer know that it's false and then say, oh, well, privilege, my lawyer can't correct that. When he waives the privilege. And he waived the privilege. He testified about this yesterday.
Okay, Ms. Cross.
I don't think that's even close to an accurate representation of what the law in this area is. And beyond the real kind of throwing out fraud and this and crimes, which what you have, Your Honor, is a conflict in the evidence at this point. I know which way the weight of the evidence appears to me, but that's going to be for the court to judge. But a conflict in the evidence, that is not a crime. That is not a fraud. That is not perjury. That's a conflict in the evidence for the court to decide.
So I agree with you there that you would have to first establish a crime or fraud occurred by preponderance. Got it. And anything else?
Just that she can't, under the guise of impeachment of this witness, number one, establish that. Number two, the witness has already said he doesn't have any personal knowledge of that. And there is the kind of specificity that is required to lay the predicate for a crime fraud exception to the attorney-client privilege is nowhere close to being met here.
Okay. Anyone else want to be heard? Mr. Sadow.
Yes, Your Honor. This is what I said to the court earlier. This is not crime fraud. The scenario in the case I said, you want me to cite it for the record?
Go for it.
Okay. It's Owens Corning Fiberglass Corporation versus American Centennial Insurance Company et al. And it is 660 Northeast 2nd, 812, out of the state of Ohio, Lucas County, Court of Common Pleas of Ohio. And it references, let me make sure I get the right page here. I think it's page 256. The point in the case, or the holding in the case, if the party or witness chooses to testify falsely, and our position is that Mr. Wade testified falsely when he claimed the relationship did not begin until 2022, that if there are attorney-client communications in which the same individual witness has told his attorney something contrary to that, inconsistent with that, here that the relationship, the personal romantic relationship between Mr. Wade and Ms. Willis began prior to November 1st of 2021, which would be the day that he was hired, that if that communication took place, that is the attorney communication, that the fraud upon the court is Mr. Wade lying under oath about the starting date, and the attorney-client privilege under those circumstances, where that material fact is pierced, and the attorney may be forced to testify to the contrary or inconsistent statement so that the fraud on the court no longer holds. In our situation, that is precisely what we are trying to do. If this witness's testimony, and the court may have to hear some of this ex parte in camera to determine. But if this witness is able to testify that Mr. Wade told him, under whatever the circumstances may be, that the relationship with Fani Willis began before November 1st of 2021, then we know from what the witnesses testified to Mr. Wade that he lied under oath to the court, and that's a fraud upon the court, and the attorney-client communication that specific matter is pierced and needs to go into the record. Now, how best to do that? The only way to do that, if it's not in writing, and apparently it's not, is for the court to hear in camera, ex parte, what the communications were that are sought to be kept privileged. If the court deems that it is not inconsistent or contrary to what's testified, then you wouldn't pierce the privilege. If, on the other hand, this witness honestly, that is, now we're talking about Mr. Bradley, actually testifies to what he has told in text messages to Ms. Merchant on behalf of Mr. Roney, that he absolutely knows that the relationship started before November 1st of 2021, then he's testifying that his client took the stand and lied under oath and therefore did a fraud upon the court. So my request is, in this regard, the court's going to have to hear from counsel, and that is counsel from Mr. Bradley, and from Mr. Bradley to determine whether or not he actually said what he said to Ms. Merchant, and whether or not it was based on communications, whenever it took place, with Mr. Wood.
All right, Mr. Sadow, I understand. Thank you for clarifying your argument there. So I understand this fraud upon the cart theory, and what I'd been going back and forth with Ms. Merchant on earlier was that, as I understood, crime fraud applied in Georgia was that the communications had to have been in furtherance of a crime. And to me, that presupposes the existence of a crime at the time, or the forming of one at the time of the communications. The theory you're putting forward is one where we go back in time and can reopen that box because it's now become relevant for something completely, potentially unconnected to the communications whatsoever. Is that fair?
That falsity has occurred now by the very person who is attempting to use the communications as a shield to protect his lives.
Okay.
And when I say crime fraud, it's a fraud waiver. That's what Millich calls it. Is essentially. Millich says that it doesn't offend the privilege to ask an attorney to testify to matters already freely discussed by the attorney and a client at another hearing or proceeding. Allowing a client to selectively waive and reassert the privilege as tactics dictates, suggests that the client is using the privilege as a sword and not merely a shield.
Sure. So I think it was quite explicit that Mr. Wade never waived anything regarding to communications between him and Mr. Bradley. He was willing to discuss the subject matter, but he was never willing to get into communications that occurred between him and Mr. Bradley. So as to Mr. Sadow's point of this fraud upon the court theory, my question is going to be, has it ever been applied in Georgia?
And the answer to that is, it's not appears to have been applied in Georgia. I cannot find a case in which it has been applied. The cases that I have, the case that I gave you plus the cases cited in there, are the only thing I've been able to locate. Although I think that the bar rules, if we're going to go back to those, and I don't have in front of me, that a lawyer should not allow his client to commit a fraud upon the court.
Okay.
And I think that, along with this, gives the court the discretion to do that. And the only way to make the record, even if the court suggests that this is the law that the court should apply, but even if the court disagrees, there's no way for there to be a record about it unless Your Honor does it ex parte in camera to determine the nature of the privilege, which of course Your Honor knows from earlier days is how judges can do it with the Fifth Amendment privilege. They can do it with any privilege as long as it's ex parte in camera. So what I'm asking the court to do, because when I get up I'm going to ask you directly. I'm not going to go through this what's going on now, to find out whether or not Mr. Wade has ever told Mr. Bradley, in his capacity as his attorney or otherwise, that the relationship started earlier than what Mr. Wade testified to.
All right, understood. So the big takeaway I'm hearing from that, Mr. Sadow, is that once again we're hearing the words "a matter of first impression" here, and noted. Mr. Gillen.
Yeah, very quickly, Your Honor. Number one, he apparently now he's claiming a privilege, which he certainly did not assert when he was communicating a text with Ms. Merchant.
Sure, but do we have any indication Mr. Wade waived it and allowed him to communicate by that text?
We know what he did. We know what he did.
So how's that an implied waiver?
And I would assume that as the attorney, that he would know whether or not he should protect a communication.
That's a pretty big assumption, right?
Not all communications are protected, number one. Number two, let's not forget how we started on this journey with the state getting up and making very serious allegations against Ms. Merchant, asking for sanctions, saying all of her representations were inaccurate. And now they are doing whatever they can to block access to that information, which shows exactly what she said was exactly the truth. What they're trying to do is they're trying to say to the court, the 100% accuracy of Mr. Wade's declaration and of his testimony. And by the way, please, Judge, don't let Mr. Bradley tell you what he knows. Because what he knows is that this relationship, based upon what we see from the text and what we've seen in the context, we show that the relationship started before November 2021. So I think we have a waiver issue, and parenthetically on the issue of crime fraud, Your Honor, the issue about crime fraud is whether or not in any context the communication would be not in furtherance of a crime at that time, but it could be for any particular crime committed by the client in the future as well. It doesn't have to be something that's being committed at the time. I will also note that when you look at the attorney-client privilege, the law basically says, look, this is a privilege which blocks evidence from coming in. And so in order to have that, they have the crime fraud exception, which is a very low standard once a prima facie showing has been made, which I believe has been done by Ms. Merchant.
All right, let me clarify one thing, Mr. Bradley. When you testify to personal knowledge, does that include anything you may have seen, heard, outside of communications with a client? When you say you lack personal knowledge, does that include anything you may have seen or heard outside of communications with a client? And you can tell me if that question was horribly phrased. Try again.
You try to rephrase it for me, Judge? I'm sorry.
Okay. When you say you lack any personal knowledge,
Yes, sir.
does that also mean that, and include anything you may have seen or heard outside of communications?
Outside of communications with my client.
Mhm.
That's correct.
Okay. And communications that were made, if any, that relate to the subject that you were asked to, were there any other third parties present that may have resulted in a waiver of privilege?
Including texts.
Am I answering your question or her question?
My question.
Okay.
Are there any other third parties ever present with you and a client that would have resulted in a waiver of these privileges?
No, Judge. I can't recall anybody being present. I mean, we ran an office. We had people around our office, but no, I can't say that there were other people present.
All right. And did you ever receive any kind of a waiver from your client at any point?
I have not received a waiver.
And anything that you learned regarding the subject matter at all, if anything, was it in the course of legal advice, of receiving or giving legal advice?
That's a broad question, Judge, to answer, because the advice was given, and then you have interaction. I mean, it wasn't, hey, this is for, to say specifically, this was for that, or, you know, I can't sit here and say that. So I don't know how to answer that question, Judge.
Yeah. All right. So
I was given a case that may reflect the same proposition I was arguing from it's older case. It's Atlanta Coca-Cola Bottling Company versus Goss, G-O-S-S, 50 Georgia Appeal 637, appears to be a 1935 decision. I've not had the benefit of jeopardizing it, so I can't say that for certain that hasn't been limited or overruled. And looks like it's in reference to maybe head note number 2, at least the one I'm looking at on the computer. And the language that is in the case, okay, is as to violations of law or commission of fraud, the protection extends only to communications after the act or transaction is finished. It does not cover communications respecting proposed infractions of the law in the commission of the crime or perpetration of the fraud. And then it cites some cases. And then it goes, the privileged communication may be a shield of defense as to crimes already committed, but it cannot be used as a sword or weapon of offense to enable persons to carry out contemplated crimes against society's frauds or perjuries. So our position, as I indicated before, is the witness, Mr. Wade, has committed perjury on a witness stand and called into question the statement.
All right, understood, Mr. Sadell. Mr. McDougall?
Your Honor, this is adjacent Georgia law, perhaps not controlling it. I'll explain that in just a second. That's Rule of Professional Conduct 3.3A2. A lawyer shall not knowingly fail to disclose a material fact to a tribunal when disclosure is necessary to avoid assisting a criminal or fraudulent act by the client. A4, and the reason I would qualify that, since we're talking about candidate report, I need to do that. I believe this rule is regarding the conduct of advocates representing clients in court. It might not govern or control the situation where the lawyer has been put on the stand, but it's adjacent to the point Mr. Sadell made earlier.
All right, fair point. Okay, Ms. Trooper, anything you want to address on that?
Briefly, Judge, and clearly there's a lot of smarts in this room, but this whole thing is a deductive fallacy. It is suggested that the truth of the conclusion of the argument necessarily follows from the truth of the premises given, when in fact the conclusion does not necessarily follow the premises. Called him a perjurist. He has officially succeeded in saying the thing itself is true, therefore we must ask these other questions. And Judge, it's a fallacy. It does not exist as such, and the privilege should still apply.
All right. Thank you all. So I think here is what we need to do, as I understand the law. As I find it, the crime fraud exception only applies when by preponderance we found that communications made in the existence of a relationship were in furtherance of a crime, or the client at the time knew or reasonably should have known that a crime, the attorney was being used to further a crime. I don't think that's been established here. Maybe something happened afterwards, and that's something that can be argued during closings, essentially. So I don't think the crime fraud exception covers this. The objection is preserved for the record. Mr. Bradley has indicated also that anything he learned about this subject occurred during those communications. There's some uncertainty on that point, and so in order to preserve the record, at the conclusion of the hearing, I think I can go in camera with Mr. Chopra and Mr. Bradley, and we can put in a sealed filing exactly what the extent of those communications were, if any were relevant. Or excuse me, not relevant, but just what they were, and those would remain sealed until some time if we're ever directed otherwise. However, at this point, the question, getting back to the question asked by Ms. Merchant, as asked, would be sustained on the issue of privilege, the premise. He may have told you something, but it does not appear that there's any evidence that the client ever waived and allowed that information to be conveyed to you. Next question.
Thank you, Judge. All right, let's see. So We talked about Ms. Willis and Mr. Wade coming to and from your office and security details following them. Do you recall that?
Do I need to look at my phone?
No.
Or can
Just asking if you
Oh,
recall.
do I recall? I think I did, yes.
Do you recall security taking Ms. Willis to your office?
I'm going to object to that.
Does he recall
Actually, I
Ms.
take that
Willis
back.
taking?
I don't object to that.
But you can answer the question, sir.
I do recall security detail bringing Ms. Willis to my office.
Okay. Do you recall approximately when that was?
I do not.
And was that on more than one occasion?
I remember 2 occasions.
Okay.
Yes.
Can you tell me about those?
I can't remember when they were.
Were they before she became DA?
So I don't know if she had security detail before she became DA. So, I mean, if she was sworn in, or I don't remember the dates, but I do remember. I think she was DA.
Maybe during her transition team period? Was that?
No, it wasn't. Trying to remember. She would have had to have been the DA, I think. And I don't want to go on, I think. But I do remember twice her coming to our office, correct?
And she had a security team both of those times.
There was yes, she has a security team with her.
Okay. And do you believe that it's a different security team than she has now?
I don't know her security team now.
Well, let me ask you-
However,
I'm sorry.
I don't know her security team now. I don't know her security team now.
Do you remember telling me that it changed at some point, her security team?
Yes, I think I recall saying that, yes.
And that the most likely people that could testify or had seen things about them having a romantic relationship early on would be the original security team?
I don't recall saying that, no, but
Do you recall talking to me about other people that might have known about their romantic relationship?
I recall.
Yeah, I mean, objection based on we don't know the source. I mean, this is either based on privileged information or it's hearsay. Neither one is.
It's neither. I asked if you recall.
You need to clarify it. If you're actually going to if you think that this draws on information from outside the relationship that he's already testified to, then you need to lay that foundation. Sustained.
Are you aware of other people that you believe would have known about when their relationship began?
I object to the relevance of that. Again, the witness has testified he has no firsthand information of it. Anything he knows about the topic came from representation. Who he thinks might have been able to say something else is speculation, not relevant to anything, and a backdoor to get in the gossip and innuendo that has been pretty much this entire.
All right. Okay, Ms. Merchant, I think we're getting to the point where, you know, the reason I thought this line of questioning was appropriate was to rebut certain inferences about why we were here in the first place.
Right.
But to go into it at the granular level, I'm not as wild about. So if maybe you can ask more overarching questions, and if you have anything else you think that's relevant, then you can get to those as well.
Isn't it true that I gave you a copy of the motion to disqualify in this case? I emailed it to you, and you read it, reviewed it, and emailed me back that everything in it was accurate, to your knowledge.
You emailed me, and
Objection.
Okay. All right. So there are things contained within that, Ms. Merchant, in which he has now said fell within the privilege, and that he did not have the ability to waive. So And that's where we have to leave it there.
And I believe I still have to ask the questions, and then if he wants to assert the privilege.
Well, I think he's pretty much already established the privilege, and the objection has been made, and I think it's a valid one at this point based on the record. So the answer was he did acknowledge that you sent him the motion, and I think we leave it at that.
Let's see. And you had knowledge about an apartment, and I'm not asking what Mr. Wade told you in furtherance of legal advice, but you had knowledge about an apartment in East Point or a condo in East Point that was owned by someone, and Miss Willis was staying there.
Judge, privilege.
I think in the way the question's phrased, she qualified that, so.
I did not have knowledge.
You did not have knowledge.
I did not have personal knowledge at all. No,
So no knowledge outside of what is privileged.
that's correct.
Did you have texts between yourself, Miss Willis, and Mr. Wade?
Do I?
Have you ever?
I have. Maybe once or twice, but
Did Mr. Wade ever ask to use your credit card to pay for trips?
Objection.
On
On privilege, I mean, we still the same thing.
just asking him to use your credit card, how's that in the nature of furthering a divorce proceeding?
We would tell you.
I had a business card, and we would use my business card. The firm would use my business card.
For travel?
Are you asking if I use my business card for travel?
Would Mr. Wade use your business card for travel?
I recall I recall a trip, but I don't know if that trip has anything to do with this case. So I do recall him using my card once.
When was that?
I don't even know when that was, and that's honest truth. I recall him using my card once, but I cannot remember what that was for. I do remember it was a trip, but I cannot accurately state, where it was and who it was with or anything like that.
And he paid you back for that trip in cash?
I can't remember how he paid. I think it was. I mean, I'm not certain if it was cash or a check. We routinely would use my card for filings, for paper, for whatever stuff with the office. And so,
oh, I'm sorry. We're done. Sorry.
And so he would, whether he paid me back in cash or whether he wrote a check, it was paid back to the business card.
But this was the only time he had used it for travel?
I cannot recall. I don't even have that business card anymore. But I do recall at least once for travel, yes.
And that was when you were still law partners with him, though, correct?
That is correct.
Do you recall approximately when that was?
I do not.
You did not go on that travel with him, though, correct?
I did not.
Okay. And so he asked you to use your card for the travel?
Yes, I'm assuming. We would use the card for firm stuff, and so it was a business card.
Your business card, though.
It was my business card, yes.
Right.
The law office of Terrence A. Bradley, correct.
Okay. So it showed up on your accounts.
That is correct.
Okay. Wouldn't show up on his accounts, though, correct?
That would be accurate, yes.
Do you know if this was before he became special DA in this case, special prosecutor?
I cannot recall.
Did you see he and Ms. Willis together? You said you were in and out of the office, in and out of the DA's office. You saw them together, correct?
In and out of my office or the DA's office?
The DA's office.
Correct.
You saw them together in and out of the DA's office?
Did I see them in and out?
Yes.
Well, if you preface it like that, no. I saw him in and out of the office when I would be there doing my filter work for the taint team.
Okay.
He would come by. I rarely saw Miss Willis and Mr. Wade together in the DA's office.
So, you brought up the taint team. Let's talk about that for a minute. Tell me about, you did work as, you had a contract as a taint lawyer, correct?
That is correct.
Okay. And that was in the anti-corruption unit?
Yes, I think so. Yes, correct.
And how did you get that contract?
What do you mean, how did I get it?
How did you get the contract?
It was...
Bid? Did you apply online?
Oh, no. It was proposed.
By who?
We were... it was proposed by... I guess it came from the district attorney. I mean, I didn't speak directly with her.
Okay.
It was with Mr. Wade, and he asked if we would be interested in having a contract with the Fulton County.
Okay. He
and I
asked
said
you
I
and
would.
Mr. Campbell?
I think so. I mean, I can't recall if he asked us both together or not. Rarely. We all handled several, different things for the firm,
Okay.
criminal, personal injury, things like that, family law. And so rarely were we together there at the same time, like for an abundance of time. So he may have called me and then he may have called Chris. I can't recall how we got the contract, but
Was Mr. Wade, to your knowledge, part of the transition team for Ms. Willis?
to my knowledge, he was part of the transition team.
Did he spend a lot of time at that office during this transition period?
He did.
So from when Ms. Willis took office to when you left the firm, did Mr. Wade spend most of his time at the DA's office?
You said most of his time, are you saying just working business hours,
Yeah,
or?
working business hours.
I would say he spent, I would probably say he spent majority of time. If you say over 51%, I would say yes, he spent over 51% of his time.
Okay. And that was the entire time from when she took office to when you left the firm?
I can't say that that was the entire time, but yes, it was majority of, it was a, I mean, I can't pinpoint specifically when the time that he would spend. I think if my memory serves correctly, getting to the majority of the time, it would have been whenever he started with this, maybe. That was
as a special prosecutor?
When you say majority of the time.
Right. Okay, so let's talk about the time before he became special prosecutor. Did he spend a lot of time at the DA's office then?
He spent time. I mean, it depends on what you say is a lot. He spent time at the DA's office, correct.
And so, just so we're clear, you were hired first on January 25th. Both you and Mr. Campbell were law partners, and you were both hired by the DA January 25th, 2021. Is that correct?
Repeat the question, I'm sorry.
You and Mr. Campbell
Yes.
both were hired on a contract basis by DA Willis January 25th, 2021, correct?
Which contract are you talking
The
about?
first one, the taint contract. Not the first appearance contract, the taint
Okay.
contract.
Well, you said the first one, and the tank contract wasn't the first contract, and so,
Okay, so what was the first contract?
to my knowledge, the first contract was the first appearance.
So let me just mark these. Let's see what number are we on. 23, 24, 25 for his contract. Judge, when they're done reviewing these contracts. This rally is showing you what's been marked. Defense exhibit 23, 24, and 25. If you could just look at those.
Okay, I see.
So on now that you've reviewed those, is it true that on January 25th, 2021, you got your first contract as a taint lawyer?
As a taint lawyer, yes, I see the date on that as a taint lawyer, but I'm also looking at this contract here for first appearance, and there must have been, I don't have it before me, but there must have been a contract before this.
Okay, so you think there's a fourth contract?
I can't say that there is or isn't. What I do know is that we did first appearance during COVID, and it was before 2021. So I don't know, if I had a contract, a written contract at that particular time or anything, but I do know, I think that you could look at the recordings because everything was recorded at that time as to when the first appearance contract started and the taint contract started.
So when the three of you were partners, you had at least two contracts to do taint work, which is filter work, and then at least two contracts to do first appearance work, pretty much throughout that entire 2 years, right?
Well, it renewed. So, it just renewed. So yes, if it was the same contract, but it was a renewal of the contract.
So how did you, and you said you got these contracts through, Ms. Willis gave them to you, but it was through her knowing Mr. Wade, correct?
Yes. I didn't have a meeting with Ms. Willis or anything. It was brought to the attention that a contract was going to be needed or awarded, and if I was interested, because this was off of mine, and I said yes, and so
Mr. Wade brought that to your attention?
He asked if I was interested in doing the contract, correct, and then after that is when Ms. Willis, would come in, or I think we actually came down here or something, and signed the contract.
Okay. And so that is how you were paid from Fulton County, these contracts.
From Fulton County government? Yes, ma'am.
And you shared, your partnership, you shared a third of all your profits with Mr. Wade?
At that time, yes.
And so his contracts, he got a contract that same year, 2021, and he shared a third of all his profits with you, correct?
Yes, that should be fairly accurate.
Okay. So during 2021, 2022, you all had 2 filter taint contracts. You had 2 first appearance contracts, and you had Mr. Wade's special counsel contracts, correct?
My firm had what I have here,
Okay.
correct?
But Mr. Campbell and Mr. Wade were part of your firm, correct?
So I don't think at this time we had established WBC.
Okay.
At this time, I think I had mine, Chris had his, Nathan had his, and we operated in the same building. But if you ask me, did we fee share, or, without everything that came in, yes, that is correct.
So you weren't actually partners, you just fee shared.
At this time, well, yes, at this time, we were not. At this time, I had Law Officer Terrence Bradley, Chris Campbell, PC, and whatever Nathan's was, if I'm not mistaken.
And all these the taint contracts and the Nathan's special counsel contracts, all of those were under the anti-corruption unit, correct? You can look.
First appearance was not under that. The taint contract, if I recall, was under the. I don't think they called it. What are you calling it?
You can take a look at your contract if you need.
Okay.
And I'm not asking about the first appearance. I'm asking about the taint contracts and then Mr. Wade's contract, which has already been admitted in evidence. If you need to look at that. Let me know when you're done reviewing.
Well, I see on the first page where it says taint attorney, and I'm trying to go through and I see where it continues says taint attorney, but it always says Fulton County District Attorney's Office. Your question was specific as to the anti-corruption unit, and I'm looking for the verbiage of anti-corruption unit, so I apologize.
No, take your time.
And see, on both pages, it starts out Fulton County District Attorney's Office, and then it just goes to initials FCDA, unless I'm overlooking where it says the anti-corruption unit, then the contract was with the FCDA. Unless you want to show me something.
I'm just asking you, and I didn't know if that would refresh your memory. Those contracts were for the anti-corruption unit, right?
Well, they were for the district. I worked for the DA.
Okay.
I worked for the DA.
Okay, so just in general, the DA.
Correct. I worked for Fulton County District Attorney's Office in as a contract person, as it says here.
And when you did the taint work, you had to report to Sonia Allen?
I did not.
You did not. Who did you report to then?
I can't remember his name. His first name was Brian.
Okay. And let's see. So I know you said you met with Ms. Willis when you signed those contracts, right?
Yes, I know I met at least one time to sign these contracts, or to sign when I signed the contracts, yes.
Did you meet with her any other times?
I did not personally meet with Ms. Willis any other time. When you say meet with, what do you mean meet with?
Talk with her, meet with her.
I mean, I would see Ms. Willis in passing if I'm walking through the office and something like that. But no, I didn't have any meetings with Ms. Willis.
Okay, so the only times you met with her were when you signed those contracts.
Clarify meet with. I mean, I
Sat down and had a conversation with her.
I signed these contracts, so when I signed these, I met with her. To say that I sat down and spoke with Ms. Willis, are you saying in life, and you saying during this time? What are you asking me?
I mean, if it's voluminous, I can narrow down the times, but I wasn't in.
Mr. Merchant, I haven't really heard a point in a while. Can we get along to something,
Yes,
or we're going to have to wrap it up?
So I had one more question about your texts. Have you ever been in any group text with anybody other than, with me, and somebody other than Mr. Chopra and Mr. Merchant?
You're gonna have to narrow that down. I'm sure you sent many
I
texts.
can look at my
of course,
phone,
it's
but-
So
like-
with him, if there had been any other texts, and I think that the state had some thing in
him
rebuttal
being-
they mentioned, so I was just trying to clean that up before it got there.
Can you try the question one more time for me?
Yeah. Isn't it true that the only texts that you and I have ever had have been between me, you, and Mr. Chopra, or me, you, and John Merchant, correct?
Can I look at my phone?
Sure.
And what's the relevance of that, Ms. Merchant?
They've said multiple times that there's this third party that we've talked to, and I'm trying to establish there's no third party. And I don't know why it was relevant, but the state's argued it, so.
Well, if Ms. Merchant doesn't know why it's relevant, then maybe it might
Okay.
become relevant later, but right now.
Ms. Merchant, I think you've been able to show
Okay.
what maybe launched this and answer the state's initial claims, and so let's get back to the core of what we were here for this hearing. Do you have anything else relevant to ask this witness?
Yes, just a few more questions. After it became known that you were placed under subpoena, did you get a call from Gabe Banks?
I did.
And was he trying to determine if you were going to be giving information in this case?
I don't know what he was trying to determine. He stated that it was an odd. I had not spoken to Gabe in a while. We are colleagues. We are friends. We are in the same fraternity, Gabe and I. And when he called, it was out of the blue. But he did call, yes, ma'am.
Okay. And you relayed that to me as well, correct?
I did.
And then you also got a call from your best friend who was relaying a message to you from Mr. Wade, correct?
No, I got a call saying that he got a call, not that a message that was supposed to be relayed to me. The call was.
I'm going to check if there's a hearsay. The response to the call for hearsay. Thus far, it hasn't. But
Sure. So here's the objection as to the contents of the call, Ms. Merchant.
I believe the contents of the call were to remember your privilege. I took that as a threat. I think Mr. Bradley took it as a threat, and I think he would testify to that.
And
hasn't testified to it. And he also said there wasn't any message relayed by Mr. Wade or any other party.
well, no, he didn't say it was by any
Right,
party.
Mr. Wade.
So assuming he did hear something from a party, what's the hearsay exception for that, Ms. Merchant?
I believe that it was a threat, so it's a statement against interest. I'm sorry, it's a if he took it as a threat to influence his testimony, then it's not hearsay, then it would be admissible.
All right, so
I did not take it as a threat.
if you're saying it's to the effect on the listener, perhaps,
Yes.
then we'll go from there.
Were you told to remember your privilege?
Your Honor, the witness just testified he didn't take it as a threat.
Understood. I'll overrule the objection and the testimony given the weight it deserves.
Can you repeat the question?
Were you told to remember your privilege?
Your Honor, can we-
I was not.
A witness, there may be a potential witness now in the courtroom, because the person that Ms. Merchant is referring to is sitting in the courtroom.
Well, if that witness hasn't been told to testify, then I don't see any sequestration issues.
I don't know who it is. I don't know his name.
Okay, and so were you told anything to that effect, Mr. Bradley?
Repeat the question one more time, but so I was not told, remember my privilege.
Something about privilege, remembering that.
I do recall privilege being mentioned, but it wasn't remember your privilege or, a threat of any sort.
But you immediately called me after.
No, I called someone else after.
You called me quickly thereafter then.
I talked to you that day, yes, ma'am.
Okay. Thank you.
Mr. Sadell.
Your Honor, because this is a defense witness, is it the state's first cross? I think that's how we had been doing it yesterday.
No, actually, we're doing it just this way.
Yeah, I've been.
Okay.
This is the first time he's gone, and then we go through all the defense, and then you'll have your chance.
Some foundation questions to begin with, please. Your testimony as you began representing Mr. Wade as his attorney on what date or what approximate date?
I didn't have an approximate date.
And give me an approximate date when you began acting as Mr. Wade's attorney.
I would say it was, if I'm speculating.
I really don't want you to speculate. I mean, you're the one that was the attorney, and Mr. Wade was the client.
Correct.
So give us the ballpark figure of when it was that you began acting as his attorney.
Maybe 2017, 2018, I think, maybe.
And the purpose for which you were retained?
His divorce.
So, according to you, from that time period, your communications with Mr. Wade with regard to the divorce or any matters related to the divorce, it's your position are confidential, are privileged, correct?
Yes. Yes.
Okay, good. Now, did you ever meet with Ms. Willis and Mr. Wade prior to, and everything I'm asking you is prior to November of 2021, okay?
Okay.
Keep that in mind. That's.
Why are you yelling?
I don't think he's yelling, Mr. Bradley. He's just speaking up. All right, Mr. Sadell, let's go.
Okay, thank you. Prior to Mr. Wade getting his contract with Fulton County, which was November 1st of 2021, okay? Please keep that in mind.
November 1st of 2021.
Right. Did you ever socialize with Mr. Wade and Ms. Willis prior to November 1st of 2021?
I've never socialized with Mr. Wade or Ms. Willis in any setting. If you're asking, have I ever met with them, then I would say yes. But when you say socialize, what do you mean socialize?
Have you ever gone out to eat with both of them?
Before 2021, I do not
Or
think
November 1st of 2021?
out to eat with both of them before. When was she sworn in? I'm sorry. When was she sworn in? There was a dinner before. When she was sworn in that I attended. Shaquille O'Neal was there, so it was like her inauguration dinner. So I'm thinking that's before 2021, so I would say
Let's
yes.
assume for purposes of my question that
Yes, sir.
that's in early January of 2021.
Oh, that is early January 2021. So yes, I mean, it will be before November. So if it was January, yes, that dinner would have been in, I'm assuming, January.
Okay. And any other time that you socialized, went out to eat, went to anyone's home, you know what socialized is?
Exactly. So no, I did not socialize with Mr. Willis. With Miss Willis and Mr. Wade.
So prior to November 1st of 2021, did Miss Willis come to your offices? Your offices, I mean the offices that you shared with Mr. Wade.
I think she came once or twice to our office, correct?
And the purpose for which she came?
I don't know. We had separate offices. I do recall.
Well,
I do recall some type of meeting happening at our office, and I don't know what that was about. I wasn't a part of those meetings. There was a meeting. There were other people there. There were other people from the, I want to say DA's office there, maybe.
Okay. Let's go back to the basics. Ms. Willis came to your offices, together offices, on a couple different occasions.
I recall Ms. Willis coming to my office at least twice.
And on at least one of those occasions, or you tell us, did Ms. Willis meet privately with Mr. Wade in his office that you observed or heard?
I can't recall.
You can't recall.
No.
Did she ever meet with you in your office? Ms. Willis now.
Privately in my office? No. I've never met privately in any office with her outside of signing this contract.
Did Mr. Wade, prior to November 1st of 2021, ever talk to you about socializing with Ms. Willis?
I can't recall.
You can't recall?
You're asking me if he ever mentioned to me that he socialized.
With Ms. Willis, correct.
And I'm saying I cannot recall if he socialized with Ms. Willis, if he ever mentioned to me that he socialized.
Did he ever mention to you that he ate or went out to dinner with Ms. Willis? Again, time period before November 1st of 2021.
Did he, repeat your question?
Mr. Wade ever tell you prior to November 1st of 2021 that he had socialized, gone out to eat, visited Ms. Willis in anything other than a professional setting?
I'm sure he did, maybe. I don't recall any specifics of any dinners, any specific places. It's been 3 years ago, the time frame, but I do not recall at this time whether or not he ever mentioned any dinners or socializing.
Did Mr. Wade mention to you that he visited Ms. Willis at Ms. Willis's then current abode, which would have been a place, not her original house, but a place she was staying in the period of 2021 before November 1 of 2021? And his question is, did Mr. Wade ever tell you that he visited Ms. Willis at her house?
I don't think I can answer that.
Yeah, privilege based on communication with my client.
All right. Mr. State, if you want to try and rephrase the question, you can, but otherwise that would be sustained.
On both grounds or just on the privilege ground?
Just I didn't hear a second ground.
It was a hearsay ground.
Oh, that would be on privilege alone.
Did you talk to Mr. Wade at all about his relationship with Miss Willis prior to November 1st of 2021?
I think he's just laying a record, Mr. Wade. It's okay. And so on those same grounds, Mr. Sadal, and all subsequent grounds, apparently the relationship with Miss Willis in any way is covered by privilege according to this witness.
Well, I think the key words, respectfully, Your Honor, are according to this witness. So I'm trying to drill down to see if there are communications that are not within the privilege.
Sure.
I can.
So then we need to acknowledge the privilege in the form of your question, right?
You're asking me to ask it as in a way saying, are there any non-privileged?
Essentially.
Okay. Did you ever communicate with Mr. Wade prior to November 1st of 2021 about Miss Willis that was not privileged?
I mean, we discussed this contract, but
This contract doesn't help. You have to give me a exhibit number, please.
you said before November 2021?
Yeah, November 1st of 2021.
Before November, this contract for 12521 is before that. So I mean, we discussed this contract.
Okay. And if I remember correctly, again, just give me that exhibit number so we can reference it.
Exhibit 23.
Okay, hold on 1 second. 1 second. On Exhibit 23, did I understand you to say that it was Mr. Wade that effect brought you and Ms. Willis together for the contract?
That would be accurate, yes.
Okay. And what did you understand was a relationship at that point between Ms. Willis and Mr. Wade, for Mr. Wade to be able to bring you to Ms. Willis for the contract? It's not a hard question. It's
No,
fairly
I'm
simple.
just state that again.
Mr. Wade is the one that basically says to you, go see Ms. Willis about this contract, right?
Mm-hmm.
That's a yes, correct?
Yeah, Mr. Yes.
So Mr.
I
Wade
apologize.
had to have some knowledge, you would assume,
Yes.
right? That you going to Ms. Willis might bring you the contract.
I
right?
never went to Miss Willis. So I stated I never went to Miss Willis. I was told about that there was a potential contract, and that I was asked by Mr. Wade if I would be interested in doing that contract.
Okay, my question to you is, what was the basis that you understood Mr. Wade being able to essentially offer you that contract on Ms. Willis's behalf?
I'm going to object to that. That's a mischaracterization. Mr. Wade offered it to him. I think he said he expressed interest. And also, I don't see the relevance of this at all.
So just in terms of relevance or phrasing, I'll overrule on those grounds. So the question that's standing unobjected to, Mr. Bradley?
Can you repeat the question?
You've explained to us how the contract
Yes.
came to you, correct?
Yes.
And my question is, what was your understanding of the relationship of Mr. Wade and Ms. Willis for it to have been offered, or whatever word you want to use, for him to have said, expressed to you whether you had an interest in the contract?
Privilege. Okay.
All right. Mr. Evans has invoked privilege on my question, so Mr. Sadal, I think you need to clarify whether...
Was it a privileged conversation that you had with Mr. Wade that let you know about the contract?
Or, it was the relationship was the question you're focused on.
Is the nature... I'm trying to do it in such a way, and I understand what the court said. Was the relationship that I asked you about just now between Mr. Wade and Ms. Willis that gave rise to the contract? Did you know about that relationship as a result of an attorney-client communication?
No, I knew of that through whatever work they did together as municipal court judges.
And how did you know that? Who told you about the work that they did together as municipal court judges?
Mr. Wade told me that they did work at some conference.
Okay, now, this would have been something that Mr. Wade said, according to your time period, at the time
that you were representing Mr. Wade, correct?
Say that again? Ask that again?
Mr. Wade would have told you what you just told the court after you had established an attorney-client relationship with Mr. Wade, correct?
Yes, but when he told me of them being at a conference, I mean, I'm not understanding how I relate. I'm trying to understand your question.
Well, my question is basically, you had communications with Mr. Wade directly that
Yes.
were not attorney-client privilege, right?
I've had conversations with Mr. Wade that were not attorney-client privilege, yes.
That involved Ms. Willis, correct?
I just stated that they were at a conference. I don't know whether or not that involved her or not.
Well, if he's talking about her, that is, if Mr. Wade is telling you about Ms. Willis and Mr. Wade having met at a conference, right, then he's talking about Ms. Willis, correct?
Yes, but he also told me about other people that he met at the conference.
But he told you about Ms. Willis as well, correct?
I think so, yes.
So there were communications in which Ms. Willis was at least a topic that was not covered by attorney-client privilege, correct?
This particular instance, I was told about a conference. And
when were you told this?
I can't remember the dates of the conference, but it was after. It would have been after the conference.
Okay, I'm trying to get just the time period here. After the conference, I want you to understand from the record, I believe we've shown that the conference was sometime in October of 2019.
Okay.
So could you give us an idea, that being a fact, when you would have had this communication about meeting with Ms. Willis at the that is, Mr. Wade meeting Ms. Willis at the conference?
If that's the conference that they were at, yes, then I don't know how many municipal court conferences there are. I do know that at the time that I was in the firm, Mr. Wade was he had some position with the municipal court.
Yeah, right now my only question is time-wise, assuming it's October of 2019, when do you tend to remember? What's your best recollection of when Mr. Wade told you about?
I can't remember because I didn't even remember that it was October 2019 until you said that.
Okay. So you don't have a present recollection?
I do not remember that, no.
Had to be before the contract, though, in January of 2021, correct?
That they met?
No, that you were told about Mr. Wade and Ms. Willis meeting at the conference had to be before.
Oh, yes, it would have been before that, yes.
So what other communications did you have with Mr. Wade about Ms. Willis that are not privileged? We know of one, about the meeting at the conference. Are you suggesting that that's the only one you ever had about Ms. Willis that isn't?
I cannot recall any. I cannot recall.
You cannot recall whether there were any other communications that weren't privileged?
No.
I'll be specific, and I understand there's probably going to be objections, but I want the record to reflect. Did you have a conversation with Mr. Wade prior to November 1st of 2021 about Mr. Wade dating Ms. Willis?
Mr. Wade has risen. An objection is sustained for the record. Excuse me, Mr. Evans.
Say that again?
You don't have to answer the question, Mr. Bradley. Next question, Mr. Sedano.
Well, I understand it's been objected to and the court has sustained the objection. Can you tell us the circumstances in which, that is, under which Mr. Wade may have told you about dating? What I want to do is try to figure out if we can, you tell me if you want me, if I can do this. I'd like to know how the communications themselves took place, where they took place, how they took place, under what circumstance, whether he was at the time providing advice or seeking advice. So those are the basics. If I can ask as to all those, but if the court's going to sustain the objection to those, then I don't want to waste your time.
And that's something I'll cover in camera. So I'll note the question and the your question for the record, and I'll sustain the privilege objection to that.
Okay, all of this prior to November 1st, 2021. Okay? I'm going to show you two text messages. I don't have hard copy. I'm going to set up a question.
Okay, so I'm going to have objections.
Of course you're going to have objections. I realize that. I want to be able to show it to him, and then I'm going to frame the appropriate question, and then you're going to object. We'll see where we are. May I approach?
You may, sir.
Look at this text message.
Oh, wait, can I read it first?
Of course, of course.
Okay. That's it.
Okay. Kind of hard to object to that and ask the question.
I know it's coming.
Okay. Then you must be a soothsayer. Mr. Bradley, I showed you two text messages, correct? Both of those text messages occurred on January the 5th of 2024 at approximately 11:56 a.m. Am I correct?
I think so, yes.
Okay. And the text messages would have been between you and Miss Merchant, correct?
I didn't see it. Yes, it should be.
Okay. And I've shown the same two to prosecution, so we're talking about the same two. In the text message to Miss Merchant, you indicated knowledge of some activity on the part of Mr. Wade, correct?
I'm going to
I haven't asked him anything about what the...
flag for the court that this is a topic and a specific exchange that Ms. Merchant went into, and there were objections that were sustained.
All right, understood.
Yes.
And it's your testimony that the information that you imparted to Ms. Merchant in these two text messages is based entirely on confidential communications between you and Mr. Wade, correct?
Objection. He's referencing specific knowledge. The specific knowledge comes from Mr. Wade, which is we've already established.
Well, no, the question, he didn't get into anything. He just said, are these two text messages about privileged communications? We haven't actually, I don't see an issue there.
Yes.
And is it your testimony that the knowledge that you have, which you imparted in these two text messages, came from Mr. Wade and Mr. Wade alone?
Yes.
Is that correct?
Yes.
Can you tell us when it was that Mr. Wade imparted this information to you?
Objection.
All right, and I think that,
That's what you're going to do.
sure, so I'll sustain that on privilege.
And I'm going to introduce for the record when we finish these two text messages so that Your Honor has those back there so that you can,
Sure, what would they be marked as?
what do you have?
I've closed that. Okay.
I'm gonna go ahead and,
Oh, the contract.
I think you were right. And the new one will be 26.
There you go.
once I put a staple in it, I think it'll be Defense Exhibit 26.
All right.
You have to give me a real pen.
All right, so this is marked and made part of the record is Defense Exhibit 26, but not necessarily for its.
This is not
Evidentiary
admitted
value.
26. This is for purposes of the court conducting the in-camera review.
Right.
And put a staple in it here to make sure that you see it.
Nope, it's free.
All right, Ms. Sadao, what else?
All right, so there was also reference, if I remember correctly, to some email correspondence in which Ms. Merchant sent you the motion that she was going to file to disqualify Ms. Willis and Mr. Wade for your review. Is that correct?
That's correct.
Okay. And that was sent to you in an email?
That was correct.
And did you respond to it in an email?
I don't think I responded to her in an email.
Ashley, do we know? You responded by text. I'm sorry, I mischaracterized it. You responded by text?
If I can look at my text, I can, but I'm assuming I did, but.
Okay, I'm going to get it for you because
Okay.
I don't want
All
there to
right.
be any assumption. As soon as we have it. Let me show you. This is the email.
Is that what you're?
I'm going to show you if I might approach. I made reference to an email that Ms. Merchant would have sent you about the motion she was going to file. If you look at this, does this appear to be the email that you received? It's dated January the 6th, 2024 at 10:25 a.m.
Yeah, I see it, the email, yes.
That's the email that you received, correct? Along with, obviously, the attachment, which is referenced.
Yes.
Okay. And then, did you respond to that email within the text message that I've just placed before you?
Yes, I said looks good.
So the answer is yes.
Oh, yes, I did.
Okay. I'm going to mark this as another exhibit for Your Honor to look at. Since you love my tongue, can I have some? Okay, I'm going to have these marked as 27. Okay? All right, so is it your position that what is reflected, let me hand it to you. Yeah. Let's of course do it, ask him not to.
We'll take it case by case. I think he's doing all right, so we'll need to ask for this witness.
Is it your position that your response, which is the second page of Defense Exhibit 27, is based on a confidential or confidential communications that you had with Mr. Wade?
Do you want me to read the response?
No, I'm only asking you whether or not the response, you actually already said what it said. I don't want you to read it again. Is that response, based on confidential communications that you had with Mr. Wade?
Objection, this is privileged and cumulative.
All right, so now we're talking about the email, essentially referencing the motion as a whole. He hasn't been asked to actually confirm or deny any specifics, just to say whether his response is privileged. So I think we're just laying the foundation, just like we did with the text message. So you can answer that question, sir.
Was my response privileged?
No. Was your response to the email of Ms. Merchant, which is on page 1,
Mhm.
is your response, which is on page 2, is that based on knowledge that you received from Mr. Wade pursuant to confidential communications?
Yes.
Have you discussed with the district attorney's office this case, your purported testimony?
Of my testimony?
Yes.
No.
At all?
No.
No prep, no conversations, no nothing?
No.
Have you given your attorneys, for this matter, did you give them permission to speak with the district attorney's office?
Well, he can assert his own privilege, but that's kind of crazy.
Is there a objection to be heard?
Absolutely, this is
Okay,
privileged.
sustained. Stay down. Next question.
Do you know whether or not your attorneys shared privileged information with the district attorney's office?
No, I don't know what my attorneys shared or didn't share. I don't know if they even met.
Have you, last question, have you spoken to Mr. Wade prior to today? No, actually, withdraw that. You're no longer in the same partnership or fee-sharing arrangement with Mr. Wade, correct?
That's correct.
When did you leave that fee-sharing partnership, pseudo-partnership arrangement?
I don't remember the hard date, but maybe sometime like July, August of 2022, I think.
Okay. And what was the reason for the partnership or the fee-sharing arrangements? What caused the separation?
I wanted to leave and go out on my own.
And that's the only reason?
I wanted to leave and go out on my own, yes.
I understand, but that was the only reason. There wasn't any suggestions or allegations of any form of misconduct on either part, either on your part or Mr. Wade's part, correct?
Misconduct of what?
Trying not to get into the specifics. Was there any allegations made of suspected misconduct on your part or on Mr. Wade's part? That's a fairly simple question. Did he accuse you of doing anything? Did you accuse him of doing anything? Without getting into what it is, were there any accusations made by you or him against each other?
We had a disagreement, yes.
And had that disagreement have anything to do with Ms. Willis?
Oh, no.
Okay. Did it have anything to do with your conduct?
No.
Did it have anything to do with his conduct?
Hold on, wait. So we had a disagreement. Whether the disagreement was, we disagreed, and so we dissolved. I left the firm.
All right. And was the disagreement having anything to do with alleged or supposed misconduct by either one of you?
I don't. If you define misconduct, I'm telling you, we had a disagreement, and we.
Just tell me what the disagreement was then.
The disagreement is mine to know. I mean, I don't see the relevance of the disagreement that I had. It had nothing to do with this Trump case or any other case.
I'm simply getting a question asked, what was the disagreement? It's not privileged, correct?
No, that is privileged.
Oh, it is privileged.
It
Why
is.
is that privileged?
Because it's privileged. I can tell the court in camera, but it was privileged.
Ask a few questions further to see if this is actually something that does fall within that privilege. We can take it from there.
Did it have anything to do